The order appointing a guardian of an incapacitated individual. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine Scale Form PC 631. Scale for State Court Administrative Office, PC for Probate Court. This Form 631 is readily available, and you're welcome to contact my office. We'd be happy to give it to you free of charge. It is used in a specific context. It's used following a petition for appointment of guardian in the probate code, and after notice of hearing, after service of process upon the interested persons within and as defined under the court rule and statute for those entitled to receive notice of a petition for appointment of guardian, and then at the end, after the court has adjudicated the petition, after the hearing, the court enters an order. And it is this order that is reflected on Form PC 631, the order of appointment of a guardian of an incapacitated individual as defined by the various statutes and court rules. Now, the floating yellow arrow is identifying the statutes and court rules that give rise to this particular petition. You can see there's a lot going on here, and it's not intuitive or simple to just navigate through this probate process from petition through entry of an order. And then, of course, after the entry of the order, it's the process of serving as a guardian, understanding your rights and responsibilities. So we strongly urge you to be working with a skilled, competent probate lawyer to guide you through the process, because it's not so simple to do. It's not intuitive or easy to navigate through this process. Let's work our way through it. Top left corner is the county. Top right corner is the case number. The top section identifies the name of the estate or the guardianship, the person upon which has been deemed to be a legally incapacitated individual. Their name is reflected there. Where it says COR, Court ORI, that area is left blank. Date of birth is filled in, race is filled in, and the incapacitated individual's current address as well as how they identify their sex. Now, it's a little weird why they're asking for sex and why they're asking for race here. It feels a little archaic, but that general information is still a requirement as reflected on this court order. The date of the hearing and the judge is reflected there. And as we continue to move through a court order, this particular one, there are the findings of the court. So again, section 2 or paragraph 2 says that notice of hearing was given to or waived by all interested persons. Now this is a requirement because the court couldn't enter an order if notice of hearing wasn't given or waived by all the people that are entitled to notice under Michigan court rule and Michigan statute. Section 3 is simply the checkbox that says that the individual is not in need of a guardian. So this would be a denial of the petition filed, and the court is denying it. That would be section 3. There's no need for guardian. Section 4 is that a determination by clear and convincing evidence. This is the standard that's required in a petition for guardianship, that the individual that's reflected in the petition is in need of a guardian by the various reasons as set forth by the statute. Mental illness, chronic intoxication, mental deficiency, physical illness or disability, chronic use of drugs, and then there's kind of like a catch-all that you can reflect other bases for why the individual is in need of a guardian by clear and convincing evidence. And not only do they meet those definitions, but there must be an impairment to the extent sufficient that the individual lacks sufficient understanding or capacity to make or communicate informed decisions as an incapacitated individual. So this is the standard that the court must make a finding of on the record before they can adjudicate the individual as a person that is an incapacitated individual. So if you have a hearing, you want to make certain that the court actually articulates those bases on the record so that the court can then enter an order. Number 5 provides that upon presentation of clear convincing evidence, a guardianship is needed as a means of providing continuing care and supervision of the individual. Another standard that can be utilized for the purpose of establishing a guardianship. 6, there could be a partial or total capacity for care. And again, with guardianship, somebody can become full guardian and address all of the care and related needs of the individual. And then, of course, there can be restrictions or limitations on those powers. So if the individual just needs a guardian for certain purposes, that is a finding that the court may make. And if the person is totally without the capacity to care for him or herself, it would be reflected in paragraph 6. Number 7 is that there's no competent, suitable person to act, and that there may be a need for a professional guardian. Now, this is an important consideration here because the court does not have the right to appoint an agency or a professional guardian or a public administrator without there being a finding, a specific finding, that there's no competent, suitable person. So in essence, all the family members have to be adjudicated or ruled by the court that they are unsuitable to serve. So if there are two people competing for the appointment of a guardian and the court doesn't want to make a decision between the two, they can't just simply say, we're going to appoint a court-appointed agency or an individual. The court actually has to make a finding that those two people are unsuitable to serve before they can go to a professional guardian. Number 8 is if there's a need for financial protection, and then below that is the order section. So after the findings of the court, now the court is making rulings that are based on the findings. And it's a little bit of a repetition of what we've just seen above. Number 9 is whether it's granted, denied of the merits, or dismissed or withdrawn. Number 10 is the identification of the person who is appointed guardian. And then A, if there's any limitations relative to those powers, or whether it's a limited guardianship. The idea of guardianship is really restorative. It's not designed for permanency, although it could be permanent. The idea is that if the individual improves or becomes able to manage and regain their understanding and capacity to make informed decisions, as well as regains their ability to care for themselves, then the guardianship should sunset, should come to an end. On the other hand, if they continue to make improvements, the powers relative to the guardianship can be limited or continue to be reduced, because the idea is to restore that person to autonomy. It's not designed for a forever or indefinite, but really as hopefully a period of time. But we recognize that some people under guardianship will remain under guardianship all the way until their death. So again, this part of the court order gives room for the court to identify the limitations as it relates to the powers of the guardian. And so if there's concern about those powers being full and broad, there should be some clarification to give the individual that's under guardianship as much autonomy and free will and the ability to make decisions as they can manage and handle. Section B is whether there's a surety bond or a bond in place, whether it's a personal or a corporate surety requirement. And this relates to financial matters, if there's finances that the guardian may be managing. But typically, when we're talking about guardianship, other than Social Security, there's generally no financial assets that the guardian is managing. That's generally done in a conservatorship. So guardian for care and well-being, conservatorship for financial. Again, these are nuances that your attorney can clarify and make sure that you've got the right structure in place for the individual. Section 11 is that a clear indication that although the court is entering an order, the guardian has no legal authority to act until the letters of guardianship are issued. So you got an order and then you got these letters. And the reason for that is the order is identifying that the person has been ruled in need of a guardian. It also appoints the guardian themselves, but it identifies how they what they need to do to qualify. So they may need a bond. They may need to file an acceptance of appointment. But until the guardian does that act, filing of the bond or filing of the acceptance of appointment, they have no authority to act. And that's what paragraph 11 is reflecting. So they file it, and then letters of guardianship are issued with the restrictions and powers as set forth within the letters of guardianship. There's a lot of confusion because people used to present the order of appointment, but the order is not the letters of guardianship. They're two separate documents, and if you have questions about these letters of guardianship, I've done videos and explanations on it. You're welcome to contact my office. Number 12 says upon appointment upon the acceptance of appointment, the guardian shall petition for the appointment of a conservator. So in the event that there's financial assets that need management, then there would be a need for the filing of a petition for conservatorship. Let's work the back side of this. Not much going on here, but Section 13 talks about the idea that a notice that once the individual is deemed to be legally incapacitated, the Michigan Department of State Police, so the state police, shall immediately enter the information into the system, the Law Enforcement Information Network. So this is a system within the state police department with shared information so that the police department is aware, because there are certain rights that relate to people that are under legal incapacity as it relates to what they're allowed to do and not allowed to do. Section 14 identifies whether, if there was an attorney appointed for the person while this petition was pending, whether they're now discharged, and whether there was a guardian ad litem appointed, whether they're discharged. Section 15 gives a broad-based space here for the court to enter any other things that may relate to the guardianship. Maybe there's a visitation component. Maybe there is some additional information that the court wants to enter in the form of an order. And this really rounds out the order section, place for the judge to sign with the date, as well as if there's an attorney that created or drafted the order itself, a space for the attorney to put their information. Again, a lot going on here with the guardianship order, and we strongly urge you to be working with somebody who understands how to navigate through this process. If you've got questions, you're welcome to contact us. Reach out to your attorney to make sure you know how to navigate through the guardianship petition through order process. At the Probate Pro, we are passionate about everything probate. If you have questions about this particular matter or any probate, trust, guardianship, conservatorship issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.